No trial transcript exists for one of history's most infamous murder accusations. Hundreds of victims are cited. A lifetime sentence is recorded, but no courtroom record survives. No verdict, no cross-examination. The record stops here. This absence appears again, centuries later, inside an industrial disaster file. Different era, same procedural silence. The accepted story is simple. Countess Elizabeth Bathory was a sadistic killer, arrested, investigated, imprisoned, justice, delayed but decisive. In the industrial age, the story repeats in a different form. A mining disaster, an accident, an unavoidable convergence of gas, error, and fate. No criminal responsibility assigned. In both cases, the public narrative says this is closure. What people think they know is that the system worked. That guilt was identified, and that process followed. That assumption does not survive inspection. The Hungarian court records list no formal trial for Elizabeth Bathory. She was arrested in 1610, confined to her castle shortly after. Her servants were interrogated. Some were executed. Their testimonies survive in fragments. Confessions obtained under torture. Statements rewritten by clerks loyal to the crown. Bathory herself was never permitted to testify in court. No defense was recorded. No sentence was pronounced by a judicial body. Instead, a private agreement between nobility determined her fate. House arrest. Permanent confinement. The official explanation is restraint. That sparing a noblewoman a public trial preserved stability. The documents present this as mercy. They do not explain why evidence was never tested. The victim count varies wildly, from dozens to hundreds. The number 650 appears in later accounts. It does not appear in contemporary records. This detail appears later. The original witness statements contradict each other. Dates don't align. Locations shift between copies. The prosecution record simply stops. No verdict document exists because no verdict was issued. This is not a missing archive. It is an absence of process. At this point, the case should collapse. Instead, it hardens into legend. This structure is not unique. When institutions decide outcomes internally, legal procedure becomes optional. The accusation replaces the trial. The narrative replaces the record. This same mechanism appears again, under different language, in the industrial age. Not with aristocracy, with labor. On December 6, 1907, the Monongah mining disaster killed at least 362 men and boys. The number is an estimate. Company payrolls were incomplete. Unregistered immigrant labor was common. The explosion was attributed to methane gas and coal dust. An act of nature. Federal investigators issued a report. No individual was charged. No corporate officers were tried. The mine operator continued business operations. The official explanation emphasized unpredictability. Human responsibility was minimized. The records acknowledge safety violations. They do not assign culpability. This detail appears later, buried in appendices. Accepting this absence has consequences. If no one is tried, the event becomes inevitable. If it is inevitable, no reform is urgent. If no reform is urgent, the system is protected. In Bathory's case, a trial would have exposed political conflict between crown and nobility. In Monongah, prosecution would have implicated industrial capital during a fragile economic period. In both cases, process was more dangerous than guilt. The language repeats. Unfortunate, unavoidable, excessive claims. Witnesses are refrained as unreliable. Numbers become estimates. Responsibility dissolves into structure. In Bathory's case, the narrative becomes monstrous excess. In Monongah, it becomes mechanical failure. Different myths, same function. The system avoids examination by closing the case without opening a court. Official explanations don't account for this. This is not an argument for innocence. It is an argument about warning signs. When accusation precedes adjudication, power is already deciding outcomes. When no one is tried, truth is not established, only managed. The horror is procedural, not personal. The legal system that never convenes cannot be interrogated, and silence, once formalized, becomes precedent. The question is not whether guilt existed. The question is why proof was never required. If trials are where facts are tested, what does it mean when history skips that step? How many events labeled resolved were never examined at all? And how often does the absence of a courtroom signal the presence of something else? The record ends early in cases like these. Interpretation begins where documentation fails. If you've encountered other instances where no one was ever tried, those patterns are worth comparing.